Record.
Good afternoon, good evening, everyone. My name is Lori Ashtok-Spivak, and it is my honor and true pleasure to moderate this panel at the second annual AFA conference. I wish we could all be in Ghana and meet each other in person, but it's a true delight to be able to connect, even virtually. So during this panel, we will speak about protecting human rights through arbitration. And in particular, we'll speak about the Hague rules on business and human rights arbitration. So as you may be or may not be familiar with these Hague rules, they've been published quite recently in December 2019, and they were developed by the Business and Human Rights Arbitration Working Group. They do not really arise in a vacuum. Rather, they represent a combination of legal development in recent years on the need to address human rights impacts on business activities and a perceived remedy gap in that respect. Access to business and human rights arbitration, as we see today, may provide a means of plugging that remedy gap with a neutral forum, and we'll discuss whether it is a positive development or not. Indeed, a number of frameworks have been developed. We'll talk about those over the last decade, including the UN guiding principles on business and human rights, amongst others. We've seen a lot of claimants also think of clever strategies through tort law, for example, to bring claims abroad and to also try to seek parental company liability. But really what we're missing is a new remedy that would be a neutral remedy and that would be really designed to address this gap. So we'll discuss that today, and we have a real distinguished panel today. So I will introduce our panelists as they go along, and as we move forward with the discussion, please do not hesitate to put your questions in the chat box, and we'll reserve quite a fair amount of time at the end of the session to address those. So first, Femi Omeri will provide an overview of the Hague rules, including objectives, goals, key provision, and we'll look at that really from the perspective of the African continent and how it came about. I'm sure you're familiar with Femi. Femi is Nigerian and a UK national. He's based right now in Tanzania. He's the founder and the managing director of Hosted in Africa Group Limited. That's basically an entity that seeks to assist the popularization of Afrocentricity and its excellence for the global good. He was called to the Bar of England and Wales back in 1999, and he's practiced in the UK for over a decade as a human rights specialist. He remains an associate member of Garden Court Chambers in London. He's been a resident in the East African region since 2008, and in addition to providing legal services in the crossover between human rights and corporate commercial law, he's become a recognized expert trainer, and he's regularly involved in capacity building projects. So without further ado, we'll listen to Femi's presentation.
Thank you so much for the introduction, and of course, thanking the organizers of this wonderful event. Much has been said about us not being able to be together physically, but we're clearly together virtually. And one thing I would say is that I'm sure the numbers of attendees over the 2 days will reflect, a solid commitment to coming together. And I'm sure that even when we do that, the virtual paradigm will be running parallel alongside to provide even greater access. So without further ado, most of you who have been to any of my presentations know that I normally kind of get people up and get them kind of moving and shaking before I start. I can't do that obviously now. Well, I could, but I won't. But what I do want to do is kind of touch on something that Professor Waid last night talked about. I mean, he just dropped a seed, but it's an important seed about our history and recognizing our history in terms of how we contextualize what is before us now. And I'm just going to kind of drop something. It's not so deep, but it's there to just remind us of the context we're in. Of course, we all know about it, but we need to be reminded time and time again. So let me just get my presentation on. This is now when technology mustn't fail me. I'm going to share my screen and stop showing the video so that I can deal with any bandwidth issues. So forgive me for disappearing. Here. Okay, 1 second. Okay. Can you please just nod if you can see my screen? It's all good?
All good.
Super.
We have been always first. Enlightenment. Plenty books to hit to come. Enlightenment. I don't need to go to come. Enlightenment. All I need to say is to set your minds to Africa. Africa is center of the world. Check your world map and see.
We all want a united Africa. United not only in our concept of what unity connotes, but united in our common desire to move forward together in dealing with all the problems that can best be solved only on a continental basis.
So the question is, what is the opportunity that's before us? Not just in terms of the Hague rules, but in terms of human rights, people rights more generally. And I'm putting it in this way, to inculcate practices of interdependence. And obviously that's in reference to Africa's coming together, that go hand in hand with the centrality of human dignity, equity, and justice, with global corporate business firmly rooted in this endeavor. Now, we may not be at that place quite yet, but surely that must be a central goal as to where we want to be. And now to the Hague Rules itself. The issue before us, and it was well summarized at the beginning, it's often, I would suggest, a question of how do we balance the conundrum of wanting to develop, very good trade flows of capital, of foreign investment, but then what are the impacts on human and people's rights, the practices of multinational businesses, their associated parties, and of course the supply chains. And of course, we've seen over the years, and definitely over the centuries, the same old story and the need for protections against business human rights abuses. We've seen, and I'm just going to flick through some of these items in silence as we kind of take them in. And it's interesting that notwithstanding quite significant harm, the journey towards a framework to hold businesses responsible to the international community is probably, well, not probably, it's a fairly recent journey. And we've seen initiatives, we've seen pronouncements, we've seen failed attempts. I'm putting up here the UN Subcommission on Human Rights in 2003. This was the attempt to create a treaty that nation states would sign up to, and that failed. Beforehand, we had the UN Global Compact launched in 2000, which was obviously laudable and is a precursor to the United Nations guiding principles on business human rights. And of course, the 2003 attempt at a treaty having failed led to a further study, a further representations being made, and by Mr. Ruggie, Professor Ruggie, which led to the UN Guiding Principles on Business and Human Rights in 2011. Now, in summary, and in lots of ways, the key features of the rules revolve around the pillars to protect, to respect, and to create a remedy. And I've highlighted the remedy because that's really where the Hague rules is based upon. But we were to do a poll, and perhaps we can quickly do it now. How many of us, and we don't need the answer right at this moment, but how many of us can say we are familiar with the United Nations Guiding Principles and so on, to what extent? And I think the poll will come around to you all. And if you can just answer that, and we can reveal the results in a moment. But I think it's worth at this stage just playing a very short video. It's only about 2-3 minutes long.
Businesses impact human rights wherever and however they operate. These impacts can be positive, or they can be negative. These days, companies are global, and that means their impacts are too. Companies operate in poor countries and post-conflict countries, in countries where the local government is unable or unwilling to enforce its own laws. With all this complexity, it's not always clear who's responsible for preventing companies from violating human rights. Is it the company's fault for paying less than a living wage? Or is it the government's fault for setting the minimum wage below the poverty line? Victims of corporate human rights abuses find themselves trapped between two actors who have no interest in making things right. In 2011, the United Nations issued a set of principles that define the responsibilities of governments and businesses for solving this dilemma. So what do these principles say? There's 3 pillars. The first says that governments have to make sure that businesses don't violate anyone's human rights. That means passing laws that prevent human rights violations, but also making sure these laws are implemented. Some of the world's largest multinational corporations are owned and operated by states. The guiding principles say that governments have to prevent human rights violations by businesses, even if the state itself is acting like one. The second pillar says that businesses have to refrain from violating human rights wherever and however they do business. That means it's not enough for companies to simply follow the law where they operate, or to audit a few of their suppliers. Even in countries where the government doesn't take up its own duty, companies have to know their human rights impacts and take concrete steps to improve them. The guiding principles don't offer any loopholes. Companies are responsible for all human rights. Doing things like building a school or digging a well doesn't get them out of their basic responsibility not to make their workers and communities worse off. Companies have to perform human rights due diligence. That means talking to the people whose lives they might be affecting. Like the government responsibility, respecting human rights isn't a switch that companies can turn on and off. It's a continuous process. The third pillar of the guiding principles is about what happens when something goes wrong. If a company abuses human rights, governments have to make sure that the court system or some other legitimate process allows the victims to file a complaint and that that complaint is investigated and settled. Companies have this obligation too. Part of human rights due diligence is allowing people affected by the company to file grievances and participating in processes to make them right. Whatever route they choose, remedy mechanisms should fit with the effectiveness criteria defined by the guiding principles. If the complaint system is slow, or it costs too much money, or it's far away, it doesn't count. So that's what the guiding principles on business and human rights say. So why are they important? First, the principles were unanimously approved by the UN Human Rights Council. Since then, they've been endorsed by governments and business actors all over the world. Before, we argued over who was responsible for preventing human rights abuses by companies. Thanks to the UN Guiding Principles, we know who's responsible. That means that instead of arguing over the rules, we can get to work implementing them.
Okay, So, as I mentioned earlier, the focus for the Hague Rules in respect of, say, the UN guiding principles is very much the issue of access to an effective remedy. And this is reflected in the principles of 30 and 31, and particularly the non-judicial grievance mechanisms and their effectiveness. As I said, this is really the kind of bedrock, the foundation of the rules themselves. And, you know, what is the mission? Effectively removing barriers for addressing business human rights breaches. You know, the barriers like the risk that the competent national courts may lack the capacity to deal with complex issues, or like the risk concerning the jurisdiction of the national courts over a sister entity or the parent company or an entity responsible for human rights abuses, or like the prohibitive costs of litigation, you know, or like the risk of political economic influence of business corporations on the state. These are real risks, and the rules seek to provide avenues to mitigate the same. And when one looks at it, it's not just a one side, and it's not to paint businesses as all, you know, evil capitalist monsters. It's to say, look, let's also provide a framework which enables businesses to kind of, you know, regulate and frame how they engage in their business, not just their singular business, but how that goes throughout the supply chain. And also it can assist states in protecting and providing effective remedies. So let's kind of move to a quick breakdown of some of these rules. So the rules, I'm sure, well, some of you may know, are based on the UNCITRAL rules, and pretty much given the latter's broad acceptance across the board. And so what it seeks to do is not to limit the scope of parties, of subject matter, and really to create a broad and flexible basis upon which parties can seek to resolve disputes. The rules extend to any dispute that the parties agree to bring to the arbitration. And there are multiple types of parties proceedings that can occur, including individual investor proceedings, which I understand is fairly novel in the arbitration arena. Normally that doesn't exist. It's normally at least investor to state or business to state and so on. But now you have that avenue where an individual itself can arbitrate alongside an investor. There's no restrictions on the modalities on how parties agree to arbitrate. And, you know, in a nutshell, party autonomy remains sacrosanct. So some of the highlight provisions of the Hague Rules tackling potential imbalances of power and inequality of arms. So Article 6 deals specifically with this. And then Article 5 deals with the issue of representation and assistance, and tribunals are under an obligation to ensure that such party experiencing difficulties as set out in Clause 2 be effective opportunity to present its case in a fair and efficient proceedings. And therein you kind of see the clear linkage to the UN guiding principles itself. And I've put here that specific principle, 31B, accessible being known to all stakeholders, groups for whose use they are intended, and providing adequate assistance for those who may face particular barriers to access. When we turn to the issue of evidence, Article 24 provides a more generous means of fulfilling the obligations concerning submissions of statements of claim and further written statements. Though extensive powers are given to the tribunal to determine in what circumstances evidence is required and in what time frame. And then in Article 32, for example, this provides for a set of enhanced tools regarding evidence in the circumstances, you know, one would find themselves in, i.e. human rights disputes. So there's a limit of scope for evidence production, power to sanction for non-compliance with order to produce evidence, adverse inferences and reversal of the burden of proof can be deployed. And items in this regard can be linked to costs. And these are flexible evidence and evidence procedures that expressly take into account issues such as fairness, efficiency, and cultural appropriateness, and have to be rights compatible. Now, when you look at these in the round, what are they targeting? And is the ability to deal with, oftentimes notorious tactics by, powerful parties to, destroy evidence and to intimidate witnesses. So these are some of the provisions designed specifically to tackle these ills that's often occur. And then what about in terms of costs? Because clearly costs of arbitration is well known. It can be pretty exorbitant. The rules have been adapted, the cost regimes that have in mind the peculiarities of business human rights disputes. And in that respect, economic imbalances, often feature in cases. And the rules provide for the assessment of financial situations of the parties regarding fees and arbitrator expenses, and can apportion accordingly. Yeah, but what's, I suppose, perhaps counterproductive, this is spoken a lot about in the literature, that costs, generally speaking, will still follow the cause. So that may, notwithstanding these advancements or enhanced cost rules in arbitration, taking into account the business human rights disputes, this may well still act as an impediment.
I mean, this is fascinating, and I hate to interrupt you, but I need to play my moderator role and give you a 2-minute warning.
No problem. This is gonna be wrapped up fairly soon.
Thank
so arbitrator qualifications, Article 11, arbitrator to have expertise in international dispute resolution and one or more of the fields to the matter in question. Obviously, independence plays a massive part, and this is flagged up quite significantly. And the nationality of the arbitrator must be different from the parties involved. And there's a recognition for the core of greater inclusivity and diversity. And the rules are pretty much, the code of conduct rules are on the IBA framework. But there's an enhanced disclosure obligations and prohibition on double hatting, i.e. you can't do this and then become an expert witness in a similar case and so on. So remedies, very quickly, just to say that they are a much broader range of remedy available to the tribunal: monetary compensation and non-monetary relief, including restitution, rehabilitation, satisfaction, specific performance, and so on. And there is, additionally, the tribunal have the power to make additional recommendations. The awards itself must in and of themselves be compatible with human rights, consider proportionality and cultural appropriateness. Applicable law, this is really very, very quick, follows the UNCITRAL model, and the objective is to really give it to the parties to create a flexible framework of what laws to apply, which can go beyond what certain jurisdictions or arrangements, BITs, may not have the provisions within their frameworks. So miscellaneous provisions, emergency arbitrators. So you can call for interim relief. This can be within 2 days of the request. Transparency is flagged up a lot, of course, reliance upon the UNCITRAL transparency rules. But having said that, this may not apply to business disputes. The protection of witness programs, which is a big thing within this overall framework for the reasons I've mentioned earlier. And what I would say is, as commendable as the rules are, the key will be its uptake given its optional quality. And And therein lies the challenge. Now, over to the debate. Thank you.
Thank you so much, Femi. This was fascinating, and it provides a perfect background from which to discuss the use of arbitration to resolve business and human rights dispute, because now we'll speak about why we should be in favor of the use of arbitration to resolve this kind of disputes. And we'll hear from two fabulous speakers, Clémence Assou and Professor Muigai. So Clémence Assou, who just turned on her video, is the registrar of the Mauritius International Arbitration Center. As registrar, Clémence heads the MIAC Secretariat, and she administers arbitration pursuant to the 2018 MIAC arbitration rules, as well as other procedural rules. In parallel, she's also legal counsel at the Permanent Court of Arbitration, where she provides supports to arbitral tribunal and assists in the appointment process, often with disputes with state entities or state to state. In her prior life, she was legal counsel in large international law firms. Professor Muigai, as you may all know, is a practicing barrister and member of the law firm Muigai LLP. He's based obviously in Kenya, has represented parties in multiple arbitral disputes relating to business and human rights. He acted as counsel for the Republic of Kenya, and until quite recently, he was the Attorney General of Kenya, and now provides also consultancy to Kenyan state bodies and private parties. So without further ado, let's hear from Clémence about some reasons why we should use arbitration to resolve business and human rights disputes.
Sure. Thank you, Laurie, and thank you to the AFA for this fantastic conference. And I'm very grateful for the opportunity to take part in this panel. So it is a pleasure to now share with you a few reasons why parties to business and human rights disputes might find beneficial to resort to arbitration for the resolution of their disputes. And over the next 15 minutes, I will first outline the advantages of arbitration compared to business and human rights litigation. And I will then show that business and human rights arbitration may complement other alternative dispute resolution mechanisms. So the features of arbitration may incentivize companies who may be less inclined to participate in court proceedings to participate in arbitration. And it may also provide to victims of corporate human rights abuses a more convenient and efficient access to remedies. So I will outline 5 features of arbitration, which are particularly relevant to a business and human rights dispute, especially when compared to business and human rights litigation. So the first feature was actually mentioned by Laurie and Femi. It's neutrality. Arbitration offers a neutral forum for dispute resolution, which is independent of both the parties and their home state. And it also avoids certain issues when going to local courts, as local courts may carry biases due to certain political influences, especially in the context of violations of human rights, which can be politically charged and entail sensitive consequences. The second feature, which is particularly relevant, is the flexibility that arbitration proceedings offer to parties. As you know, arbitration is based on the consent of parties, and as a result, they are not bound by rigid rules of civil procedures, and they are able to customize the proceedings in line with the specificity of their disputes and priorities. So this flexibility appears in the choice of the applicable law. The parties can carefully select the best legal regime supporting their rights and the enforcement of their awards. Parties may also choose where to hold oral hearings, if they are to take place at all. And you might know that there are a number of cases involving African parties and abuses committed on the continent, which are currently or have been tried in Europe and in North America. So one of the advantages would be for the proceedings to take place on the continent and for the hearing to take place on the continent. Arbitration can also be designed to be faster than domestic proceedings. So instead of the 5 to 10 years that court proceedings often entail, arbitrators could issue a final award in a much shorter period of time. It is also possible to seek emergency relief to provide for expedited or fast-track proceedings. And this is relevant, especially in cases where there are some human rights urgencies, and there is a need for protection. And then the last aspect in relation to the flexibility is the fact that it is possible to conduct more efficient proceedings. So it is possible to consolidate proceedings, and also to provide for a rejoinder in order to avoid multiple parallel proceedings going on at the same time with regards to similar sets of facts. And it's also possible to resort to innovative procedures that could result in improved decision making. For instance, be able to conduct site visits when relevant. The third feature, which was also mentioned, is confidentiality and transparency in business and human rights disputes. Arbitration has the benefit of allowing the parties to create a custom-made transparency regime for each business and human rights case. So this allows aspects of the process to be publicly known while keeping confidential and by keeping sensitive details confidential. So this confidentiality could be relevant not only to protect certain business interests, but also to benefit the victims who, as Femi mentioned, could be under some sort of witness protection measures. The fourth feature regards the selection of arbitrators and counsel, as arbitration provides for great freedom to the parties in the selection of their adjudicator, and they can choose individuals who are specialized in the field of international human rights, but also have specific knowledge of an industry. It's also an opportunity for parties to choose arbitrators with diverse backgrounds who have legal and cultural expertise to be able to understand the cultural context of the dispute, which might not necessarily be the case if it is tried, for example, in the context of a dispute involving corporate abuses in Africa, if it is to be tried outside of the continent. Similarly, there's also some freedom with regards to the selection of counsel, which means that parties are not limited in their choice of counsel as to who can appear in domestic court. And last but not least, awards are potentially enforceable throughout the world, including under the New York Convention, which is not necessarily the case for court judgment. So at the moment, there's 168 state parties to the New York Convention. So that gives you an idea of the number of states an award can be enforced. I will now finish my presentation by discussing briefly how arbitration can complement other alternative dispute settlement mechanisms. So we heard today about mediation and the progress that that has been made in relation to the enforcement of settlement agreements resulting from mediation, which is fantastic. But there is still a long way to go. And at this stage, it will be easier to enforce an arbitral award than a settlement that is the result of a mediation. So it could be in parties' interest to conduct mediation or other forms of collaborative settlement in parallel to arbitration proceedings. Whilst they are discussing, they could stay the proceedings. If they reach an agreement, they could then seek a consent award from the tribunal, which would transfer their agreement into the form of an award, which would be enforceable. And should the parties fail to reach an agreement in the context of mediation, they would not have lost too much time, and the proceedings would be able to resume and result in the issuance of an award. So I hope these speeches were convincing, and I thank you very much for your kind attention.
Thank you so much, Clémence. This was enlightening. And so we'll hear from Professor Mugai if he has any comments on the reasons why we should use arbitration to resolve human rights dispute.
Thank you very much, Madam Moderator. Now, it's very nice of the organizers to have invited me, and I'm very grateful for this opportunity to share my reflections on the subject. I also wish to acknowledge that my colleague, Clement, has covered the ground very, very extensively, and therefore my job is made that much easier, and I'll therefore be donating some of the time you have allocated to me for Q&A. But I just want to make a couple of points that the reason arbitration commends itself as a process, as opposed to, say, for example, litigation, is particularly because of the power imbalances that exist between big businesses, particularly multinational businesses, and the victims of human rights violations. And the necessity to address that power imbalance is at the heart of the Hague rules on business and human rights. And if we acknowledge that, we will then be, we will then see the necessity of this alternative dispute resolution mechanism. The other issue that is very important for victims, as has already been mentioned, is the diversity that arbitral processes can bring if properly used. In the area of international commercial arbitration, Africa has not gotten a fair deal. And we all know that most international commercial arbitration disputes are settled in forums far away from Africa, although discussing African problems or claims. The majority of the people involved in these arbitration processes are non-African, and the representation of African jurists, for example, is very, very low. And I think that arbitrating human rights claims arising out of the continent will help to address this imbalance, because the rules recognize that there ought to be a diversity in the tribunals, and I think that that is absolutely critical. It is also important to note that the requirement that the arbitral tribunal should have expertise touching on business and human rights law and practice, that is absolutely essential, because again, it is necessary, as we all appreciate, that there is sensitivity to the special nature of human rights violations. And I think in the Q&A, we will have time to go into that, what we would mean by the expertise being sensitive to certain things. Now, again, the question of the representation of victims. And again here, I don't want to give the impression that the arbitral process is merely for the benefit of the victims. It is equally to give a forum for the alleged violator to exonerate themselves with evidence or otherwise and so on. But why I am particularly concerned about victims is because, as we mentioned earlier, of the power imbalance that has traditionally existed. Again, the rules are specific about cultural appropriateness. Now, I don't want to overstate this case, but as we all know, what today passes for international dispute resolution processes can be quite culturally detached from the victims, especially from developing countries and especially from Africa. And that these rules are very sensitive to cultural appropriateness, I think, is important in making the case that this method is much better than otherwise has been the case. The rules address, as we were informed, the whole question of evidence. All of us who come from a background of the common law, for example, know, and I'm sure it is not different from the civil laws regime, that evidence can be quite problematic if it is technicalized like we do in civil litigation, and it can be a hindrance to achieving justice. And that the flexibility that arbitration accords around the question of evidence, to my mind, makes it a very, very useful process. My colleague talked about a number of things which I don't want to repeat. The neutrality of the forum, that is important. The speciality of the practitioners, that is important. The binding nature of the awards. Costs, again, costs, we were addressed on that already, but even as important as costs, that is to say, we can keep costs very, very, very low in arbitration, but it's quicker, it's faster, and it's therefore potentially saves all the parties a lot of agony and expense. And I think that the whole issue of party autonomy is also very important. The parties continue to structure the kind of process they want. And as you will recall, as many people will recall, when we think about the Bangladesh Accord arbitration, which came out, which eventually had, I believe, a satisfactory end. The parties retain the right to be able to timeously bring the matter to a fair and just conclusion. And I hope that I have said enough to make the case for arbitration as a dispute resolution mechanism in the area of business and human rights. And I return the floor to you, Madam Moderator.
Thank you so much, Professor Mugai and Clémence. I'm convinced, but now we will hear from your dear opposing counsel on this case, because let me add that right now we're going to discuss the reasons why we should not use arbitration for purposes of resolving human rights dispute. And the case against arbitration here is not a personal case of Dr. Felrath and Dr. Sally Alsawa. And so we will hear interesting arguments, and we will have the opportunity to think outside the box. So Dr. Felrath is a Swiss qualified lawyer. She represents parties in domestic and international arbitrations before tribunals. She also is a litigator, and she serves as an arbitrator in many institutions, including on the African continent at the Kigali International Arbitration Center and at the Lagos Court of Arbitration. She has particular expertise in environmental and energy law, and she regularly publishes in English, French, and Italian in her areas of expertise. She also has taught for a while at the University of Glasgow and Lausanne. She's now counsel at Swiss Legal Rouillet and Associés in Lausanne and Geneva in Switzerland. Isabel, we'll hear from you in a minute. Let me introduce as well Dr. Sally Alsawa. As you may know, Sally, she's the founder and partner and principal of Alsawa Law. She's French and Egyptian qualified. She's also a registered foreign lawyer in England and Wales. She's been practicing arbitration for over 14 years, both in international law firms and as an independent practitioner. She has acted as counsel, presiding arbitrator, co-arbitrator in arbitrations under multiple rules, and she regularly also appears before Egyptian and French court. And she was recently appointed as Deputy Secretary General of the AFA as of February 2021. So congratulations, Sally. So without further ado, we'll hear from Dr. Felrath first.
Well, yes. I will try to share my screen. Can you see it well? Yes, no?
Yes. Yes, you may want to put it in slide mode, but we can see it very well.
In slide mode, that is it for me? Oh, yes. I will do that, yes.
Yeah. Perfect.
Okay. Well, Laurie, you were saying right. I'm going to literally use the usual elementary trial technique to rebut the argument that we have just used, because I think that it's quite nice to be also to play the devil's advocate, and I do thank you for letting me, giving me the opportunity to do that. I'm trying to explain, to argue the case as to why arbitration is, in my view, and based on the experience I have, not a silver bullet for the adjudication of business-related human rights disputes. Now, I start by the end because I don't want to be completely unpopular by us from the very beginning. So in order to make sure that you understand me right, I have to say what I agree with. I agree that business should be held accountable for human rights, social rights, indigenous rights, minority rights, and environmental law infringements. But I'm not sure that, considering the intrinsic feature of arbitration, that arbitration is the adequate way to achieve such a business accountability. And I'm going to use 3 times, each time the same pattern. I will first state the main arbitration feature, then rebut the adequacy of this main arbitration feature from a human rights dispute perspective, and give you an illustration of the point. And the main arbitration feature, which I'm going to address some of them very rapidly because Sally would be addressing them more extensively, is the consent approach, a national private forum, substantive law dilemma, transparency deficit, parties' asymmetrical needs, and appropriate remedies. And I find it very interesting to have chosen these because I realize that these points were exactly those made as, or presented it as advantages earlier on the panel. Illusory consent to arbitrate. Premise, it's a main arbitration feature that the consent is the source, but as well as the limits of the arbitral jurisdiction. And it is a necessary prerequisite to secure the enforcement of an arbitration awards. When it comes to bilateral investment treaty, we consider that the arbitration clause that has been signed by the state in the investment treaty is what we call the standing offer to arbitrate, which companies would adhere to by filing for arbitration on the basis of these investment treaties. Now, I consider that this consent-based mechanism, contrary to what has been argued as a main advantage, essentially, by Clémence, I think that, generally speaking, firstly, it would be very difficult to know who would have the local standards to find a case on human rights basis. Would you have class arbitration? Sally is going to be discussing these about these, and I'm not going to expand more. When it comes to victim-to-business disputes, that is, when a victim files a claim against the business, I think that it is very unlikely that the business would agree to arbitration, considering that this arbitration could open or could pave the way for further these similar disputes. When it comes to state-to-business or business-to-business disputes, parties, private entities or private or human rights victims would not be a party to these proceedings because they are not a party to the commercial contract, because they are not party to the host or foreign state. They are not a foreign or host states, and therefore they are not party to the bilateral investment agreement either. And therefore, it would be very difficult to obtain the consent to arbitrate. An acknowledgement as an illustration, as Femi has mentioned earlier, it is a consent issue has been acknowledged in the arbitration rules, in the BHR arbitration rules, and in fact the consent is not being defined. An illustration of the difficulty of consent didn't use specific African cases, but one of the very famous cases, the Texaco, or the Chevron, what is called the Chevron case, where you had two arbitration proceedings involving the states and the company, and a series of litigation that were involving more the human rights and environmental actors to try to make their claim effective. So you realize that you didn't have a concentration of a whole dispute, and arbitration was eventually not used in that particular case. Second, I think that arbitration is inapposite because it's private and it's an national forum. What has been presented earlier as an advantage to me is a disadvantage. We know that the main arbitration feature is its inherent private essence. I'm not going to read the famous quote for Polanski. You have many other quotes. And international arbitrators are usually considered as being national, not related to a particular judicial system, which has been presented as an advantage. And I took the opportunity of putting a quote of Professor Gaillard's famous legal theory of international arbitration as an homage to his great work. Now, a private and a national forum to plead a human rights case, I think a private forum would not be a proper place, as it would be operating in a business settings. And it thinks that such settings is inapposite to resolve human rights issue. And also, I think that a private forum has no legitimacy as a state would have to enforce human rights and to secure human rights compliance. As an illustration of this point, again, this difficulty has been acknowledged in the BHR arbitration rules. And I am also quoting a report, a very damaging report. It's not recent, but still interesting, that reminds you the limits of arbitrators. Corporate arbitrators are not natural guardians of the public interest, but of business interest and of a new industry that has of experience, so has privileged investors over the public interest. Are these really the person we want to entrust with the protection of human rights? I'm not sure. Thirdly, another point that was invoked as being an advantage, which in my view is not, is the applicable law substantive dilemma. Now we know that one of the main arbitration features is that arbitrators are going to decide the disputes primarily in accordance to the terms of the contract, to the chosen law, and to the most appropriate law. Now, of course, the rules provide some specificities, but nevertheless, human rights are not necessarily part of the bundle up that would be referred to arbitration. Firstly, international investment and commercial law are, of course, not concerned with human rights. I'm not saying it's good. I'm saying it's the truth. It's a fact. And another fact, they tend to be construed regardless of any human rights and more and dearer to my case, environmental concerns. Second, human rights instruments are meant to be vertical. They govern state to individual instruments, and they have a very limited horizontal dimension, that is, individual to individuals or business to individuals. So basically, from this result that commercial entities would be only limitedly exposed to human rights infringement. And conversely, the host states that may have failed to protect human rights could be self-exposed. And in fact, we would not necessarily target the entity we wanted to target in the end of the day. Thirdly, of course, human rights standards are proliferating, but in non-binding ways. Code of conduct, rules, general guidelines. And there is a clear reluctance wherever we go to impose legally stringent obligations. Switzerland was recently, Swiss people has recently confirmed that it was all nice to have a number of rules, non-binding rules, but no firm rules, clear rules in relation to, in particular, Glencore's activities in Africa, for instance. And the last one, there is no, and last point, which seems problematic to me, is that there is no agreed conflict of law in case of conflict between investment and commercial law and between human rights law. Who should strike balance? The arbitrator? Should human rights law apply as a mandatory law and supersede any other legal order? An illustration of this problematic, again, Ecuador case, where the company was awarded plus $2.4 billion US, whereas it was recognized that it had massively infringed human rights and environmental laws. Transparency deficits, again, an advantage that was presented, I think, by Clemence in favor of arbitration. While we know one of the great features of arbitration is not only hotel rooms, but it's confidentiality, privacy, no publication of the awards, and it's generally related to the private character of arbitration. We consider that when the party decide to go private, then they also want to keep the matter confidential. And it is a fact that confidentiality is very, very effective indeed, and very convincing for companies, and it would often loosen the tongue of all people involved. Now, the downside of this for human rights abuses is that the transparency deficit of classic arbitrations make it inherently unsuitable to litigate public interest issues such as human rights. First, that's going to be behind closed door arbitration that would allow the companies to keep the low profile on human rights abuses. And it would be outside the media coverage, which yet has a very powerful impact in terms of disseminating the information. Secondly, the confidential arbitration and unpublished awards would have a very limited deterrent effect and would have no incentive really on companies. They would indulge into risk management strategy, and the recent total explanation of its situation in Myanmar is one illustration of this. Again, transparency deficit, as Femi mentioned, has been clearly acknowledged in the arbitration rules, and it is also increasingly discussed in the investment law and city cases, but it might eventually backfire and incite companies to abandon this kind of processal means. Fifthly, there are parties' asymmetrical means. Professor Mugai alluded to power imbalance and between the parties. While I would say that sadly this power imbalance would be perpetuated, not resolved by arbitration. The arbitration feature, just very quickly, is designed, the parties are free to design the arbitrator, to fund, they must fund the arbitration proceedings, expert fees, costs, hearing experts, report costs. They would have to plead their case in compliance with the rule, and they will have to bear the cost and the expense of the awards once allocated. Well, there can be, in my perspective, no fair trial and equality without equal means. Most even individual and groups of human rights abuses victims are not familiar with arbitration technicalities and strategies. Big companies are, and they are very well informed, and they have a long way ahead. There is no state aid it's unlikely, and I think Sally will mention this, but the experience made it's unlikely that TPF, third-party funders, would take a case involving high-profile human rights case. They have no interest in doing that. And a difficulty that no one is discussing is the difficulties to find suitable experts and suitable arbitrators that will be willing to sit on a sensitive case, knowing that this could prejudice their future appointment. That's rash, but that's a reality. On cost, illustration on cost, the BHR, indeed, arbitration will contain a provision to cut costs. My view is very unlikely to be realistic. On the sensitivity of human rights for arbitrators, I'm not going to go into polemics, but I think that's a recent event that happens to a very famous UK chamber following a report by one of its members on the situation of Uyghur people in China that resulted in a sanction imposed by China on that chamber that resulted in the prominent arbitrator, part of this chamber, to quit the chamber overnight, is quite illustrative. And last element on which I'm going to go very fast because Sally will address this more into detail, the inappropriateness of remedies and limited enforcements. The arbitration feature is classic, only the award would dispose only the matters that are referred to arbitration. Awards are final and binding, but only on the parties, and they can be enforced, but only by the parties themselves. I think it's dubious that human rights are arbitrable, but I'm open to discuss. I am more than dubious than the satisfactory remedies are going to be awarded through human rights arbitration, although I take the FEMI's point that there are some accommodation for this. I refer to Sally's presentation, indeed possible monetary compensation, but it's very little and it's very unlikely to incite long-term changes in business practice. And there is also a paradox in there. I think it's quite interesting to claim bypassing a state judiciary on the ground that it is not independent enough to adjudicate claims, yet to envisage to plead human rights abuses through proceedings that could, if they are investment related, potentially include that same state as a party. I'm not sure I understand the logic. And the third point is the non-enforceability of an arbitration by a third party. If an NGO or people would make amicus curiae brief, they would not have the possibility to have an award enforced. Only if they are direct parties would they be able to enforce it. The illustration is one I mentioned earlier is Total Puyana is in a declaration in the Burma-Myanmar situation a few days ago actually, where it really, I'm not going to read it, but this explanation of Puyane, which is a very skilled manipulation of the fact, shows how difficult the situation is and how there can be no simplistic, easy solution. Now, these are no longer the points, but there are possible leads, which I'm not going to discuss because this is not the topic. I'm not saying that human rights and cannot have any incidence on the promotion on arbitration itself and cannot have some impact. But I'm just thinking that it's not the ways, it's not through human rights arbitration that we would be able to do to achieve this. Back to you, Sally.
Thanks so much, Sally, please.
Thank you very much, Isabel. Good evening, everybody. Thank you for staying with us until late. I would like to thank the attendees and also President Chief Bayo, Dr. Rukaya, and Dr. Adeyemi, and the members of the boards, thanks to whom this conference is a success, notwithstanding the difficult moment everybody's living with COVID-19. I am a bit with Isabel in the difficult position here because we're advocating against the Hague rules on business and human rights. We are advocating here against arbitration and a conference dedicated mainly to arbitration and ADR practitioners. And when we hear the human rights, we think about the rule of law, and therefore we would be advocating against the rule of law also, which definitely not the purpose. If we are advocating against business and human rights, we think also about the weak parties and the strong ones. And from what we have heard from Femi, now the MNEs are considered as the new colonizers after the colonial era, the end of the colonial era. So we are the devil incarnate. However, if we think about it, what if we think about the whole thing as we are not actually advocating against arbitration, but we are actually advocating against the rise of this type of disputes for the sake of arbitration, to protect arbitration and its perception by the public at large, is the business and human rights arbitration, and not only the Hague rules, not in fact a threat to the viability of arbitration as the dispute resolution method in matters involving public interests. Yesterday, we heard about predictability, visibility, legality, legitimacy, and consistency of arbitration awards, which led to the current reform of ISDS. And when I was hearing them, I was wondering if we're not talking about the same reasons for which we should advocate against business and human rights arbitration. After all, these are the same reasons. If we look at what's at stake right now, coming to the substantive rules, we are in presence of fragmentation of rules. Yesterday, we heard the term spaghetti ball, which I actually like a lot. And the spaghetti ball led to contradicting words and lack of predictability, lack of accountability, and even challenge of the effectiveness of the arbitration mechanism all in all. We have heard from Femi that what triggered the BHR Hague rules are actually the United Nations Guiding Principles on Business and Human Rights, which were endorsed only in 2011. And if we look at the origin of actually these principles, we will go back to the Declaration of the Millennium, which later on led to numerous new declarations by the UN General Assembly and the UN Secretary General in favor of contributing to a socially sustainable globalization. We hear today, and this is really, as a matter of substance, really related to what's going on in business and human rights arbitration. We hear today about ESG and CSR, environment, social and governance, and CSR, corporate social responsibility. However, although in environment, there is a plethora of rules and policies around more than 1,500 national, international, regional, and sub-regional rules in matters of environment. There are the rules coming when it comes to social and governance, the rules are still embryonic. And of course, human rights involve environment, but it also involves other aspects which are mainly covered by the social and the governance. And it's here where the norms or the rules are very scarce. And there is another element that also complicates things when it comes to substantive rules, which is supply chains. Supply chains and BHR or business and human rights in general involve issues of extraterritoriality. And therefore, how would the arbitral tribunal, supposedly we get over the problem of consent that Isabel talked about, how when it comes to substantive rules, which rules to apply, and when it comes to vulnerability and marginalization, when it comes to rights of indigenous people, women, national or ethnic minorities. We all have in mind the Orbazer versus Argentina exit arbitration, where the arbitral tribunal has admitted the principle or has recognized its jurisdiction to hear the counterclaim of the state. However, it dismissed it on the merits. And in this case, actually, the UN guiding principles have been invoked, and yet the arbitral tribunal dismissed the claim, ruling that, in fact, notwithstanding all the rules that the guiding principles, there was not in effect any binding rules upon the investor. And if I may, I'll read it very quickly, this excerpt from the tribunal's award. In light of this more recent development, which is the UNGPs, it can no longer be admitted that companies operating internationally are immune from becoming subject to international law. On the other hand, even though several initiatives are undertaken at the international scene are seriously targeting corporations' human rights conducts, they are not on their own sufficient to oblige corporations to put their policies in line with the human rights law. So, and again, it is when you are in the context of perception of arbitration and all the criticism that is here right now when it comes to ISDS, and you hear an award dismissing counterclaim or concerning human rights, you, or at least the public at large, have doubts about the legitimacy and the accountability and the fairness of the system, which we all know. Of course, it has its flaws, but it's a system that is here to exist. Arbitration is good, and otherwise we would not have been arbitration practitioners today. So this is, of course, when we say unpredictability of rules, we say contradiction of awards, and we have examples of court decisions that themselves have applied contradicting reasonings and decisions. So when it comes to arbitration, it will be even more difficult. How would arbitral tribunals decide and apply, which rules will they apply in case of gross human rights abuses in conflict affected and high risk areas? And this leads me to the second issue, which is the effectiveness and efficiency of the business and human rights arbitration. And I will not address it from the perspective of effectiveness of the award, which involves issues of arbitrability and whether the business and human rights claims can be characterized or fall within the criteria of commerciality or public policy. I will not address these. I'll tackle it rather from the perspective of effectiveness of the arbitration process itself. And here, coming to the last example I've had given, which is the human rights abuses in conflict affected and high risk areas, which is, by the way, not a hypothèse d'école, as we say in French. There are OECD due diligence guidance for responsible mineral supply chains, which apply, concern also the human rights abuses in conflict affected and high risk areas. And you have the Lusaka Declaration of the International Conference of the Great Lakes region. So we are not, and again, hypothèse d'école. But coming to this scenario where you have an arbitration involving this type of disputes. First of all, by the way, I'm here talking, I'm addressing what Clémence have said among the advantages of arbitration is that they provide innovative procedures and the like site visits. Honestly, which arbitrators can go, an expert can go and would be willing, and if we put aside the willingness, their ability to travel to conflicted zone to conduct site visits and appreciate evidence. And among the principles of the UNGPD is a test of proportionality. They check if to see the responsibility of the business, they look at the size and sector of their activity and the severity of impacts of their activities on human rights, among others. How would they adopt and apply this principle of proportionality? How would they be able to investigate the severity? Something else also, which is comes to the issue of lack of effectiveness and also lack of accountability. If you know, the Article 19 of the Hague Rules on Business and Human Rights provides for multi-party arbitration, including class actions and joinders, under two scenarios. The first is that the party or third parties beneficiaries are beneficiaries of the underlying legal instrument that includes the arbitration agreement, or that these parties are beneficiaries directly of the arbitration agreement themselves. So coming to the class action, there is an issue of consent, but there is also an issue of arbitrability, not only of business and human rights, but it's a classic question on international arbitration in general, which is class action arbitrations. And even if you overcome the problem of consent and arbitrability, how about case management and the fairness of the proceedings? And what if there is the scenario of joinder by the state? What if the state is here actually to support the MNE, saying, listen, I have made these decisions power as a foreign and as a sovereign, and I have used my sovereign and inalienable right to choose
Sally, I'm having some trouble hearing you.
System, my political, social. Where did I stop? Where did it stop hearing
It's
me?
kind of slowing down, but I also need to give you a 1-minute warning. This your dear
Yeah,
moderator.
I'm
Thank
at
you.
the end, by the way.
Great.
I mean, so what if the state is here to advocate with the MNE against the human rights? How would the arbitral tribunal, which is supposed to apply rules of the state, say, no, actually, I am using my power as an arbitral tribunal to appreciate whether you were reasonable to sacrifice the public interest in favor of the minorities or vice to the detriment of minorities. So these are real issues. And this is why all in all, I consider that the BHR rules in arbitration right now is first premature and also out of sync. Premature because the substantive rules are not predictable yet, they're still embryonic, but it's also out of sync because it does not learn the lessons from the problems we face right now in ISDS. And instead of saying arbitration is a redress, we are in Africa, we are talking about building capacity, at least let's form the judges and let's try to develop the rules and try to give our capacity building for politicians and the legislative arms of the government, of our governments, to develop rules about ESG and CSR. And once this is well set, then arbitration can come to place. Thank you very much.
Many thanks, Sally. And maybe I should invite all speakers to turn back on their videos. And I just wanted to thank both you and Isabel for rising to the challenge of advocating against the use of the rules. I think for now, what we'll do is try to open it up for questions, because I would love to have some debate with the audience and take a little bit of time to hear people's views and questions on the issues. So let me see if anyone among our attendees would like to either raise their hands or add questions to our panelists in the chat. I'll give it a second, but maybe just to start, it's always like this when we start Q&As, and then the first question is always the most difficult. I would like to ask you a little bit about how do you foresee the use of these rules? And we've talked about the issue of consent. How much do we think large multinational companies would consent to arbitrate supply chain related human rights dispute, either through arbitration clause, but with whom, or through probably more likely arbitration agreements after a dispute has arisen? What are your views? And maybe unless anyone, yeah, Femi, go ahead.
I'll jump in, and this is more thinking on my feet on this particular matter. One of the things that's obviously happening across the board is the extent of public opinion, and the fact that all companies now are in the public glare, and these issues are becoming much more of a board issue as well. And of course, there's the issue of kind of mitigation of risk and so on. But where the issue of human rights and human and people's rights emerges that much more, and it's happening from so many different angles. We can bring in, Black Lives Matter or what have you, environmental movements and so on. There's a groundswell of public opinion that is going to start to shape how businesses operate, and we're seeing it. This is tangential, but you've seen companies raise their hands and say sorry for wrongs of the past that would never have happened before. So I don't see that this is, it may be that, yes, I take the point that it's embryonic, it's new to the forum, but it's one of those, and I use this phrase a lot, the living instrument syndrome. This is not something that just stops here. It's going to gain ground, and we're going to have more of these debates. And I think over time, that kind of separateness between where the line is drawn, and we've seen this in criminal liability, for example. We've seen this a big time come in, where all of a sudden there is no room, there is no hiding place for certain types of criminal acts. And that, I think many of us believe, it is going to crawl into all our systems. There are going to be certain actions that you cannot run from wherever it is you are, and they will be announced, they will be kind of litigated, they will be being able to be articulated in the various forums that we kind of operate within. And whether that means that it stays there, that's maybe the point. So if it's properly recognized, what do you do to the arbitration? It could be, okay, right, we need to now stand off, and that needs now to go to the requisite body who will be more specialist in that area. But the idea that it's not something that ought to be very much central to whichever forum is being is in question is, I think, is becoming more and more redundant.
Thank you, Femi. And I see a question from the audience that's related, where one of our colleagues, Ivan Dubruva, explains that his understanding is that even if there are rules of procedures and arbitration rules, the main difficulty remains the arbitration clause and the competence of the arbitral tribunal to be able to take care of human rights abuse. So what would be the steps going forward to include human rights concerns in an arbitration clause? Any of our panelists, maybe Isabel, any feedback on that?
I would maybe just, I will get back to this afterwards, but I would just maybe react to Femi's comments and complement or reuse what Sally said earlier. To me, the main weakness is not procedural. I think you can create all the bodies, all the adjudication, the new mechanism. Don't forget that we have quite powerful human rights institutions that are probably working, not always very well, but they are working. Why should we need more? I think that it's not by creating new mechanisms that we are going to reinforce the loopholes in the substantive law. And this is the point that was made by Sally earlier. To me, the main weakness is not procedure. The main weakness, and these are also the 3 points that were made at the end of my presentation, is the fact that human rights are not integrated well enough. And it goes back to the question into the substantive documents, into investment treaties, as usually expressed into general ways, and also in the various laws, domestic laws of the host state. And I don't think that this loophole, this weakness, is going to be compensated by new instruments. And to me, without a carrot and without a stick, they are not going to buy. Multinational companies are not going to buy for arbitration. And I go back to Femi's point. I think that, in fact, multinational companies are well aware that arbitration are, like American courts, willing to adjudicate, to allocate huge costs, disproportionate costs, that they don't feel is disproportionate when they're arguing their own case about tax evasion, taxation issue, nationalization, expropriation. There they are willing to go into billions. But when you come to human rights infringement, they are not willing. So they're not going to take the risk. The best way to include human rights into arbitration, into the contract more than into arbitration, is to have proper, powerful contract. We discussed about it yesterday, and we heard some presentation that increasingly we have host states being willing to be more regarding as to what is being made into their countries on human rights standards, on environmental standards. But it's, to me, the key point are the host states, not really the multinational companies. For as long as the multinational companies are free, they will use this freedom. And what is happening now in Myanmar or Burma, or however you want to call it, with Total is quite illustrative. Total is, I'm not saying that they are not right, but they're clearly distorting a bit the reality to show that they're good, but still say, well, what can I do? Because I don't have the government assistance in this respect. So the short answer is the contract. The investment contract should integrate as a contractual duty of the investor into the host state respect of human rights. Now, as to whether the host state is going to respect the human rights itself is another question.
Sally, Clémence, Professor Mugai, do you want to react? We have 2 minutes left.
I just want to make one clarification. We seem to be proceeding on the basis that there will be arbitration only if there was reference to arbitration in some contract. We must remember that reference to arbitration can and does occur after a claim has been made. And after the claim is made, then the parties then say, look, whatever the merit of your claim, take it out of any litigation, and let us sit down now and have an arbitration process that we agree upon ex post facto. That's very important to make the clarification. Secondly, I know of personal experience here in Kenya that a very large Kenyan company owned by a UK company in part has had its parent company settle a very large claim, which many of you may be aware of, in the UK. And I therefore do not agree that companies generally will not be interested in arbitrating claims, because as Femi said, the reputational risk is growing. I'll stop there.
Thank you so much, Professor Mugai, for this perspective. And I'll send back our attendees also to the Bangladesh Accord PCA arbitration that resulted from the claims in that context that show exactly what you explained, Professor Mugai. So I would like to thank very much all the panelists, AFA, the AFA board, the AFA Secretary General, Dr. Rukia Baruti, for the excellent organization, and all of our attendees. And I wish you all a nice end of conference.
Thank you.
Thank you.
Thank you.
Thank you.